thank you everyone for being here today. We're really excited for our time together. As Annalisa mentioned, I'm Nguyen Tara Key. I'm Executive Director of Programs at California Forward, where our vision is to build a new California economy where people across every region and every community can prosper, both today and into the future. And we do that in a variety of ways and have core strategic priorities on advancing a Regions Up agenda and also a stewardship agenda, recognizing that California is a wealth of resources, economic, natural resources, community resources, and stewarding those for the future is critical to our goals here. And we also at California Forward put together our annual California Economic Summit, which is our signature event of bringing organizations in public, private, nonprofit, and other entities together to really catalyze action in moving our California agenda forward. Just a quick background on where this webinar came from and our work on broadband as part of that broader ecosystem and movement that we're working to build. California Forward was one of 8 organizations and tribal groups that received a PUC, California Public Utilities Commission Equity, Engagement, and Education Grant in 2024. And this grant program was designed to increase participation of tribes and community-based organizations representing underserved communities in the PUC decision-making process. And we're really thankful and grateful to the Public Utilities Commission for this opportunity, which has enabled us to host this session here today. At the California Economic Summit, our Broadband for All working session focused on this grant project and really served as an important place for us to hold a conversation around ways and exploring ways to foster greater engagement before the Public Utilities Commission. And as a next step coming from that important engagement at our summit, what we learned there at that session and partnered with 2 experienced digital equity groups to present 2 trainings. And last Friday, we were thrilled to work with Oakland Undivided, who presented a powerful training on general strategies for engagement with the PUC. And it's wonderful to see some of you who attended last week also joining us here again today. And today, during today's training, we're very fortunate to have Paul Goodman, who's General Counsel at the Center for Accessible Technology, here with us to discuss more formal means of engagement. And Paul has extensive experience practicing before the California Public Utilities Commission and working on digital equity issues. And last week, one participant referred to him as a national treasure. And as I'm sure as I turn it over to Paul, I think it will be very obvious why and how that is true. So with that, I want to turn it over to Paul. Thank you again so much for being here today and really looking forward to this conversation.
Thank you so much. As I've said before, I love doing these events. I am super excited about it, getting folks excited about CPUC, which I guarantee you will be by the end of this presentation. As has been said, my name's Paul Goodman. I'm an attorney with Center for Accessible Technology, or C4AT. C4AT basically works on digital equity issues for folks with disabilities. One of the things I like to say about sort of disability equity is it is about as intersectional as you can get, because there is not a demographic. And we always say, if you're lucky to get old enough, you'll have a disability. I also love to point out that some of the most amazing broadband technology that's come out of broadband, like a lot of other technology, started out as accessible technology. So voice to text, audio description. Actually, the technology we're using right now, video conferencing, started as video relay services for folks who use sign language. So yeah, I'm really happy and excited to do this work. But let's jump right in, because I probably have 2 more slides than I should, but that'll be fun. Let's get my presentation started up here. All right. So yes, you'll see my contact information here. It's also at the end. I have an open source brain, so I really encourage you to reach out if you have questions. And I'm happy to try and answer them. Also, I'm not a super formal guy, despite the outfit. So if you have questions as we're going through this, just kind of feel free to ask them. I'm going to try and keep an eye on the chat, but if you also just want to jump on your mic and ask the question, you can ask the question. But let's dive right in. So if you go to City Center in San Francisco, there's some really gorgeous buildings, right? There's City Hall, there's the Federal Building, there's the Veterans Center, there's the old library, which is now the Asian Art Museum, and then there's this thing. This is the California Public Utilities Commission, which is kind of a brutalist. You could almost miss it compared to other buildings kind of building. It's not on purpose that it looks like that, but I think it's for me, it's a good analogy because you only hear about the Public Utilities Commission when it's not working as it's supposed to be working. It's just like, you don't think about where your drinking water is coming from until you turn on the faucet and the water doesn't come out. But it is a hugely important agency in California. It's actually so important that it was created by California constitutional amendment rather than just being created as an energy. And it is the agency that is in charge of communications, energy, transportation, and water companies. Not all of them, and not every single thing they do, but yeah, they have most of the clout. And the commission consists of 5 commissioners who are appointed by the governor and confirmed by the Senate. They serve 6-year terms, which are sort of staggered because basically sometimes folks serve their full term and then they find a new one. Sometimes folks leave early. Just it varies quite a bit. And then there are a whole bunch of staff who do the thankless job of getting into the nuts and bolts of what's going on. So all the way down to how loud does the whistle on a train have to be when you're driving through Jack London Square in Oakland. Really detail oriented. Why do we have the CPUC? Well, I have an answer for you. This is Jay Gould. He was a railroad magnate, and he used his political influence to get the government to help him buy a bunch of railroads and create a monopoly. This is Thomas Edison, who was famous for being an inventor, but he didn't really invent stuff. He just bought or stole it and took credit for it. And then he was really good at working the media into thinking he was a genius. The good news is it's the 21st century, so we're now so efficient, we've been able to combine that into one person. But I think these 3 individuals are all a really good example of the outsized amount of power industry, or I shouldn't say power influence industry, can have over policymakers. And the Public Utilities Commission was originally the Railroad Commission. And it was originally, when it was created, it was put in San Francisco. And the reason for that was they wanted to have it far away enough from Sacramento so that there wasn't undue influence. And that's really important. So one of the reasons the CPUC was created is because it would have sort of an independent authority and the independent ability to take care of things without having to worry about politics so much. Whether that has been successful is a different question, but one of the great things about the commission, it is really not afraid to sort of go its own way. The other reason is this. Folks who have been to maybe a presentation or 2 of mine before will recognize this. On the left is a historical redlining map of the city of Oakland. The areas in red were the areas where basically communities of color and low-income folks were like, that's where they got to live. They weren't allowed to live anywhere else. And in those areas, there were no financial instruments available. You couldn't get a mortgage or mortgage insurance, whereas you could in the wealthier, whiter areas. And that led to historical discrimination, which we call redlining. On the right is a map of broadband service quality and adoption. So Red's where it's, and orange is where it's worse, green's where it's better. I'm just going to go ahead and rotate one of these maps so they line up a little bit better, but you can see they overlap almost exactly. So when it comes to broadband availability and quality, it exactly sort of mirrors historical redlining. And in another presentation, I could connect all the dots for you. You could draw a straight line between redlining, which was a government-sponsored project, and where we are today. Oh, I just got a message. The folks cannot see my slides. Is that correct?
I can see them.
Your
I can
slide.
see them.
All right.
Yeah,
Good.
if somebody is having an issue seeing a slide, you can maybe message Annalisa, Deb, myself, and we can try to troubleshoot, but I'm seeing them, Paul.
All right. I hate for anyone to miss this. So the commission basically is controlled by the California Public Utilities Code. It consists of 35 different divisions, each of which has multiple chapters. Each chapter has multiple articles, and each article has multiple sections. So it runs from section 1, so I think like section 242, 350. Like there's not every single number. So it's massive, but the really two key things to know about the commissioner are found in the California Constitution and in Public Utilities Code section 451. Basically that the commission can set rates, create rules, can investigate, and can punish public utilities, so providers of these water, energy, communications, transportation. And Public Code section 451 that basically says, hey, any charge charged by a public utility in California has to be just and reasonable. It has to be fair. I would double click on Patrick's recommendation that you read The Color of Law by Richard Rothstein. It is a work of genius. And so I want to talk a little bit about the CPUC's role and scope, which is like I know a lot of folks who do legislative work in Sacramento, and they're fantastic. They do stuff that I just don't have the skill set to do, and it's amazing. And none of the folks I work with, but folks I've worked with in the past who do work in Sacramento will be like, we passed a law, we succeeded, we win, woohoo, let's all go home. And that's where my work starts, because yes, we can have a law, but then we have to implement that law. And that's what the commission does. So I quoted here one of the Public Utilities Code sections talks about grants from the broadband grant account, which basically says, hey, the commission's responsible for administering these grants. So the commission has to sit down and figure out how to do that. Other things I want to sort of emphasize is if you're a public utility, you can't do business in the state of California until you get permission from the CPUC. And at heart, and it's something that a lot of policymakers don't really understand sometimes, the CPUC is a consumer protection agency. It is, I would say, the CFPB for electricity and communications. That's what they're there for. I'll just warn you, my next slide is designed to make you panic a little bit. So don't have to read all of this or understand it today. But as I was preparing this presentation, I just thought down and say, well, let me put down all the moving parts that are involved in regulation. And this is just the communications regulation and broadband and telephone and video service. So it involves a whole bunch of different technologies. It involves a whole bunch of different services, and then it involves a really wide range of stakeholders, right? Everyone from regulators or government agencies to providers and industry groups, to labor, who are hugely important, not just because they're labor, we like labor, but because they have a ton of technical knowledge about how networks work and how the equipment works and what kind of state it's in. And then consumers, and I would also group in consumers, say communities. I particularly want to flag tribes as important stakeholders because in California, if you want to go find the worst communication services in the state, go to tribal lands. It's shameful, but we are working. So that's sort of like all the parts that are involved. So you've got a bunch of different stakeholders with different perspectives arguing about rules for different services, all of which run on different technologies, and it starts to get really complicated really fast. That doesn't mean it's difficult. There's just a lot of parts. And then I think my last, second to last, but on role and scope, I've already talked about the first bullet points, but the commission's scope of work involves what I would call nose to tail public utility service. So everything from the poles and wires that deliver your telephone service, or the pipes that deliver your water, or the wires that do or do not deliver electricity, depending on who your provider is. What kind of service quality you get, making sure that that service is affordable, particularly for low-income families. There's affordability programs. And then all the way down to if you have a complaint as a customer, they will deal with that too. And this is one of the most effective ways as an individual you can do work at the commission. If you are having trouble with any of your utility providers, you can go to the commission website and you can file a complaint. And when you do that, put in your complaint, Paul Goodman from Center for Accessible Technology said I should file a complaint. The reason is those complaints get forwarded to your provider. And the one string I have to pull in the entire universe is hopefully someone will see my name and freak out and fix your problem right away. I hope that works. But those complaints can be really, really effective if you just need someone to fix your service right away. And then finally, I cut out a whole bunch of slides about actual commission process here, because you can boil it down to say that it's a process that a lot of administrative agencies use called notice and comment. So they send out a notice of, hey, we think we're going to change some rules here, or we'd like input on what our rules should be. Please provide that input. Folks are given a chance to provide comments and provide data. And then after that collection process, the commission issues a decision. Also note here that proceedings are supposed to take no more than 18 months, but sometimes they take a little bit longer. Finally, at the bottom here, don't have to worry about reading that entire thing because I have it on virtually every other slide in this participation. This is my little diagram of like a proceeding start to finish. And the reason I have this like this is I'm going to use it to identify every single place you can make your voice heard in a commission proceeding. So if my slides have had the effects I kind of intended, I feel like some folks are starting to feel their chests tighten up, or maybe the room's getting a little bit warm. Totally normal. When you first look at what the commission does, and you look at the subject matter, and you look at all the requirements, it seems really complicated and really daunting. And you're like, I have to be some sort of weird genius to do this work. That's not true. It's actually amazingly simple. There's two sort of things that people get intimidated by. One is subject matter, and the other is processes and procedure. I want to talk about both of those, but we'll talk about subject matter first. But we'll get to that. So this next section is entitled Obstacles Participation, but that's actually an incorrect title. The title should be Gatekeeping, because a lot of what happens at the commission is gatekeeping. There's just not necessarily intentionally, but a lot of the weird procedural requirements and the language we use makes things inaccessible for folks. So the first one, this big one, archaic grammar and fossil words, we have a great example of that, which is a term I used before, which is just and reasonable. So just is a word that means fair. Reasonable is a word that means fair. One has its origins in Old English, and one has its origins in Norman French. And when the Normans invaded England in 1066, they started this practice of combining those two terms. So you have a lot of terms like metes and bounds, or heirs and assigns, or just and reason. That got carried over to the United States. Now, my typical response to this is, we, for the most part, won the Revolutionary War. Why are we still using something from 1066 as terminology? But attorneys love to cling to it. So that is, yeah, the language is a big thing. Procedural rules are sometimes really nitpicky, and you can get a document rejected for not having page numbers or for using the improper font or whatever. And at the beginning, it's really frustrating. But I'll tell you, I've been doing this for coming up on 14 years now, and I still get documents rejected. It's just weird. It's just, there's a lot of stuff to know and you don't always remember it all. And finally, existing practitioners, and unfortunately, it's not just restricted to industry, practitioners really try to use the system and use their knowledge of the rules to bully and intimidate new participants. I have one other gatekeeping thing here, which is this. There is no reason I need a jacket and tie to give this presentation. There's technically no reason when you go to the commission to hold a hearing or appear at a pre-hearing conference, you should have to wear a suit and tie. It's ridiculous. I'm going to lose this right now because it's a bit warm in here. And quite frankly, I'm in my socks and wearing jeans. And they're jeans I've worn more than once this week. So, but it's one of those really gatekeepery things that makes no sense. But let me demystify some. So first is this concept. People think you have to be a lawyer to practice at CPUC, and you don't. And actually, it's one of the few spaces in a lot of arenas of law, like if you're doing litigation in court, if you try to represent someone else and you're not an attorney, you can get in trouble. Here, that's not the case. Anybody can be an advocate at the CPUC, which is fantastic. Also, law's not that bad. Some of you may have seen this. Let's talk about just how legal analysis works, because people get freaked out by legal analysis. So I have two statutes here, which I've made up from our California bird law statutes, right? First one is chickens have pointy beaks and do not have webbed feet. The other one is ducks have rounded beaks and have webbed feet. So I have a question. What is this? Folks have an opinion, please shout them out. Okay, good. Duck chickens, excellent. Chuck is good too, right? So if we look at the first statute, we can say, all right, this doesn't have a pointy beak, and it doesn't have webbed feet. So it's not a chicken because it needs a pointy beak. You look at the section, it does have a rounded beak, but it doesn't have webbed feet. So it is not a duck. So technically it is neither. But there are some reasons you might want it to be a chicken or a duck. For example, if you're a poultry breeder and there is a $1 fee to the city for every chicken you own and a $2 fee for every duck you own, you want that to be a chicken. Right, but this is at heart all legal analysis is, right? There's a question, there's an issue, there are some rules, and you are applying facts to those rules. And new attorneys and law students always make the mistake of thinking the law is the most important part of that analysis, but that's not true. It's the facts that are the most important part of that analysis. I'm going to come back to that repeatedly. I also want to talk about policy, because I have a couple other laws here. One is like a chicken coop has to be at least a certain size, right? a duck shelter must include access to swimmable water. So whether that's a chicken or a duck might actually matter. But also looking at this particular bird, I don't know, it doesn't have webbed feet. Maybe it doesn't need swimmable water. Maybe it needs both a lot of space and swimmable water. That's the other part of CPUC advocacy, is not just sort of let's talk what the law is, it's let's talk about what the law should be. And a lot of times I think about, like, you get a lot of discussion at the commission where we talk in big generalizations, right? And California is a big place. So it's not like we can say, here's a broadband solution that's going to work for every single person or every single community. And where providers are always trying to push for solutions that A, make them a lot of money, and B, are easy for them to administer. So they want it to be the same everywhere. But a lot of communities are like this bird. They're not quite a chicken, not quite a duck. So a cookie cutter solution's not going to work for them. And so policy arguments are really a chance to say, hey, here's a scenario where this is not going to work. And it's also a really good chance to say, hey, should any of these rules apply? Do we need a new rule? Or even are there some rules that are outdated? So that's really at heart the law and policy argument here, is saying, okay, we have a problem. How do we solve that problem? Do we have a solution that exists already that will work, or do we need something new? And I will argue that anybody in this room can talk about that. The second big obstacle is procedural. So this is just one section from the Public Utilities Commission's Rules of Practice and Procedure. And all this particular section does is say, okay, here's how your page has to be formatted when you're filing a document. By my count, it's got 13 different requirements in it. So everything from margins to font size to spacing to it has to be bound in the upper left-hand corner, et cetera, et cetera. It's a bit much. And you can blame me for this. You can blame attorneys for this, because if you give attorneys an inch, they will take a mile. And if you don't have really strict requirements about this is what your document's going to have to look like, who knows what your document's going to have to look like. But the reason you should always try to follow these rules and should be concerned about them is that, but you don't want to be paranoid, or you don't want to be dissuaded from providing input to the commission because you're too worried about conforming to these rules. Because the worst thing that happens is you get your document rejected. But if the commission rejects your document, basically they say, didn't reject this. Here's a nice email explaining exactly what you have to do to fix it. And if you fix it and resubmit it within 7 days, we're going to pretend you got it right the first time. So, and that's one of the fun quirks of administrative law, I guess, is that really if something gets done wrong, the solution is, all right, we'll just do it again. So these rules can really cause a lot of panic and anxiety and all that, especially when you're rushing to finish something by a deadline. But there is virtually nothing you can do that will end up with you not being able to provide it. I would also say you don't need to get a paralegal, I don't think. Actually, what you do is you email me and say, hey, I'm writing this kind of document. Do you have like a template I could use? And I'll be like, sure, use this one. And you'll be fine. And then I want to make my my last little ranty point here, which is like, so I have been doing this for a very long time, and I am really good at writing legal and policy arguments, like really good. I can write the best legal argument in the world. I can explain why it's important till the cows come home, but I cannot win without stories. Like hearing from communities is critical because otherwise the commission's not going to have information that it needs, or it's going to say, okay, we've come up with a solution that doesn't actually work for everybody, but then they wipe their hands over it. They're like, we're done. And then you've got to like, then you have to start pushing back and saying, no, wait, it's not working for some folks. And it's a big thing. So really key. So I am encouraging you to basically help me knock down the gates. Get in there and make your voice heard. I'm sure everyone's heard the term, if you're not at the table, you're on the menu. That's especially true here. Thank you for the Princess Bride love, because I was like, I think I can get away with 2 Princess Bride references in this presentation. So there you go. All right, the next part is not nearly as exciting because it's more procedural stuff, but I really want to point out how easy it is to participate. So here's sort of what a proceeding looks like start to finish, and we'll talk about each of these components, but I sort of break it up into 3 different groups. I'm not sure anyone else does, so maybe don't talk, if you're talking outside of this group, maybe don't refer to the 3 different groups because they're not going to know what you're talking about. Or if you do, just say, oh, Paul Goodman, and the people go, oh, that guy, that's fine. So there's a bunch of steps which are part of opening a proceeding and figure out what the issues are and who the stakeholders are and that sort of thing. That's the opening proceeding part. Then there's a part in the middle, which that will be sort of the most, I don't want to say confusing, but complicated because it's a little more free form and things can but don't have to happen. But that's really the portion of the proceeding where you're collecting factual information and telling stories and researching policy and law to come up with solutions and propose solutions. And there's the sort of post fact finding or post hearing stage where the commission will issue a proposed decision and then get input on that proposed decision and then create final rules. And then way at the end there, which we're not going to talk about too much today, is there's what's called an application for rehearing, where you basically say, hey, commission, we don't agree with your decision. You need to fix it again, you need to fix it, which rarely is effective, but it is a procedural requirement if you're then going to go to court to challenge the commission's decision, but rarely happens. And one other concept we have, it's what's called the record. The record is, and its most simplistic form, a bunch of banker's boxes that have all of the documents that are part of the proceeding. So all the comments folks have filed, if anyone has provided testimony, if there's transcripts of the proceeding, those go in there, exhibits that parties have introduced, filings, that sort of thing. And the way to think about it is when the commission is forming its decision, right? And if it wants to provide, say, data or information or a story to back up its decision, they have to be able to pull that out of one of those boxes. So say, for example, here's a story we've heard more than once from folks. It was very depressing. So people say, hey, so when we're out in a rural area and when it rains, our phone service stops working. So if we want to call our neighbors for help, we have to go outside and fire a gun into the air 3 times. That is an actual story I've heard. That story is great, but if I have not somehow memorialized that story and gotten it into the commission's record, the commission cannot rely on it. So creating the record is really sort of the end goal. It's just making sure the commission has the information it needs to support its decision. The last thing here is one of the really cool things about the CPUC is it has this rule. So I don't know how many of you watch a lot of courtroom TV shows. There's always objections, sustained, denied, and all that. It all has to do with basically what we call the evidence code. So the evidence code says, hey, some kinds of evidence can come in, some can't. Like hearsay is the big one, always people are always talking about. Well, the commission's rules actually say, hey, the evidence code is cool and all, but we don't actually have to follow it. So really, to get information into the record at the commission, all you really have to do is say, this is relevant. Like, this is important for people to know. At the commission go, okay, thank you. So do not be intimidated by, particularly when, say, you file something and then a provider comes back and says, well, this is inadmissible for all these reasons, the evidence code. Because then you can just respond with, only question is whether it's relevant, and it's relevant. Thank you. So don't let them bully. But let's talk about, say, once we have a proceeding, how to go about it. And there's really two big ways to make your voice heard at the CPUC. I don't know if Patrick talked last week about the third way is you get a bunch of angry people with signs and you show up at the commission, which can be effective. I don't know if we talked about that or not, but it's a third way. I don't have one here. But they're sort of broken into, there's two activities. There's one, what we call public comment. Right, that is where you can go to the commission website and go to a particular proceeding page, and there's a public comment section, and you can go in there. Hey, here's my concerns, or here's my input. In proceedings, they will have what's called public participation hearings. They're usually scattered all over the state, and you can show up to one of those and speak and say, hey, here's my story. All of those are great, and the commission refers to them and keeps them in mind, but they're not technically a part of the record. So if public comment is the only evidence the commission has, they can't rely on it as part of the decision, but they can use it to sort of bolster evidence that's in the record. This is really easy to do. Like, you could wake up at 10:30 or 2 o'clock in the morning with a thought and zip on over the commission webpage and then type your comment in and send it off, and then wake up the next morning and go, oh God, what have I done? But yeah, it's really straightforward and easy. It is less impactful for a few reasons, some of which are legitimate and some are not. Again, I think for me, this is a really frustrating piece of gatekeeping, because I think it allows stakeholders and policymakers to be a bit dismissive of communities, because you know what, participation as a party in a proceedings, it's some work, and work costs money. And I don't think that there's a bunch of folks going to the CPUC website and making up stories about their experiences. So yeah, I can't say I'm fully in, like, the public comment process should be more impactful than it is. The way you really make a difference is by participating as a party to a proceeding, which is a more formal route, requires a little more procedural knowledge. And by procedural knowledge, I mean you send me an email and say, can you walk me through this? And a little more complicated, but it has more impact, because you're basically submitting official documents in the official part of a proceeding, and you're basically, it's much harder for folks to hand wave away what you say. So I'm going to talk quickly about how you participate, become a party in a proceeding. There are basically three ways to become a party. And people usually always take advantage of the last one, because they're like, we're not sure if we're going to file comments or not. And they're like, oh, we're going to file comments. Well, then you have to become a party. And at that point in the process, the only way you can become a party is by filing a motion for party status. And you usually have to do that while there's a deadline for comments, and then becomes a sort of scramble to get all of that stuff together. And I'm sure there are folks on this call who could tell horror stories about what that process is like. It's not super difficult, it's just time consuming. But there's other ways you can do it. One is when there's a document that opens a proceeding, if you file comments on that document, you automatically become a party to the proceeding. That one's pretty easy. I don't ski, so I don't actually know how difficult skiing is, so this may be inaccurate, but I'm like, you're just kind of going downhill. It's great. The other thing you can do is shortly after the document opening the proceeding gets filed, there's what's called a pre-hearing conference, which we'll talk about. you can just show up at a pre-hearing conference and ask to become a party. That's slightly more complicated. It's more like climbing uphill. Clearly, I like going downhill more than I like climbing uphill. A little more work, but not too bad. Filing a motion for party status is like fighting a bear. Difficult, and not in terms of it's hard to do, but just in terms of the amount of effort required. And I always try to emphasize this. You can become a party to the proceeding and then never do anything ever again, and nothing will happen. It's at least at my organization, we default to filing comments on opening documents. So we become parties, and then as things go along, say, hey, do we need to be in this proceeding? I'll stop there and see if we have any questions before we jump into my cool diagram. No? Oh, I better move right along here because I'm a little behind schedule. So jump past this here. So in this opening a proceeding part, there's what we call an initiating document. So it could be something filed by a stakeholder, like an application. The commission could start a proceeding on its own, and it starts with a document that looks kind of like what I've got here on the right. And it just says, hey, we think you should look, commission, you should look into this issue. Or the commission issues one that says, yeah, we're going to look into this issue. I have this in green here because that's an opportunity for you to get involved. You can file comments on that document. We have thoughts about we should do this. So if the commission says, oh, we should increase the eligibility guidelines for, say, Lifeline, which is the subsidized broadband plan for low-income folks. You can say, that's a great idea, and here are the reasons we support it. After those comments come in, the commission sets what's called a pre-hearing conference. Those are weird because when you show up, you're just there to talk about process stuff. So you don't actually talk about the issues. You talk about to say, hey, what's the category of this proceeding? Not important to know for today. What's the scope of the issues we're going to discuss? Is there a proposed schedule? We're going to do this, and are we going to need hearings? Are we going to need workshops? Or do we need testimony? But you don't actually talk about, hey, what should the commission do? But this is just to sort of figure out who the stakeholders are, figure out what the schedule ought to be, and what everyone's going to be discussing. But that's a great chance to become a party if you haven't already. And the last piece of that is the commission issues a scoping memo, which is sort of like we heard the input from everyone at the pre-hearing conference. So here's what our scope of issues is going to be, and here's what we think the schedule is going to be, and here's whether we think hearings are necessary, and we're going to hold workshops or public participation hearings or what. And the commission will sometimes, but not always, ask for comments on the scoping memo. Once all that's done, now the proceedings really roll. And that's when you could start building a record. I'm not going to go into depth on this slide, but at that point, you can start doing discovery requests on other parties to proceed, which I would say is a sort of a varsity team process, because you're basically saying to providers or other parties, hey, give me all the information you have that supports your argument. Or say AT&T, show me how much it costs you to actually provide service in this area. And filing discovery data requests is really easy to do, but it's a really good opportunity for parties to just just waste your time, burn up time pretending to not understand, generally being jerks. So I would be, as always, I'm happy to do a separate section on discovery requests, but I want you to be aware that it's there, that you can actually you can get information from other parties in the proceeding. It's very powerful tool. And then depending on the schedule set in the proceeding, there are a couple different things, some or all of which can happen. And there's first is what we call workshops and public participation hearings. So public participation hearings are, as I said, members of the public can come and make their voices known. If you are a party to a proceeding, you are not technically a member of the public and therefore cannot make a statement in public participation hearing, but that's fine. But you can certainly organize other people too. Workshops, the commission will often set up if there's something technical or they want to know more information. So I've pushed for workshops before where they say, hey, you know what, we need some input from users of the subsidized telephone service. And we should find some unhoused folks or folks in the in SROs, in residential hotels and all that, and find out what their communications needs are and what works and doesn't work for them. So you'll have a workshop like that, or you can have a workshop that's about highly technical stuff, like what happens when you send an email across the internet. Those are meant to help sort of the administrative law judge and the commission understand sort of the issues more in depth. And it's a chance to really focus in on specific aspects. Often the commission will ask for testimony. And so what's kind of a neat aspect of the PUC, unlike in a typical court hearing where your testimony, you get up on the stand and your attorney asks you some questions and then their attorney asks you some questions. The first stage of testimony at the commission is written. So you just do written testimony where you're like, here's what I think. I'm a witness, here's what I think. And then the other parties have a chance to file what's called rebuttal testimony or reply testimony. And at that point, if there's a hearing, then you get into that in-person cross-examination. But testimony is a really good way to focus in on the issues that are important to your constituency or to you, and say, hey, here are the important things, and here's what you should know about. And the third piece is sometimes there will be a staff report. So staff will take all of the information that's collected so far and come out with a proposal. And then you get a chance to comment on those. So yeah, all of that is sort of information gathering, and that can lead to an evidentiary hearing. Evidentiary hearing is what the part of the process that looks most like what you think it'll look like. It looks like kind of a mini trial. It is, again, I'd say that's a kind of a varsity level activity, but there you can come to an evidentiary hearing and not ask any questions, just observe everything, take notes. It's fine. And then after the evidentiary hearing is closed, the commission seals the record of the proceedings, so you know exactly what's in the record, and then they ask for briefings. So your brief is like your treatise about here's how things should work out. So you say, here's what the facts showed, here's what the law says, here's what the policy should be, here's our outcome. And you submit that, and then your work's kind of done. Then you just have to wait. I'll stop there because that was a lot in a very short amount of time. And I want to make sure I got it across.
Paul, I know that all of these steps might feel overwhelming, especially when there are, by kind of statute and structure, multiple points of engagement. Can you share a little bit about like the requirement to engage in everything, or like which one of the, like, do you have to do one to get engaged in the process and then you can participate in reply comments if you didn't do initial? Can you just speak kind of to like, if I want to get engaged, but I don't think I can do everything, maybe where should I prioritize engaging along this process?
Yeah, that is a fantastic question. And you know what, one of the disappointing things about being an attorney is like our typical attorney answer is, well, it depends, but I don't have that answer this time. You can participate in one of these or some of them or all of them. You are not, like, by becoming a party of proceeding, you are not binding yourself to doing anything. So, and I'll sort of say, so a workshop is, the comments on a staff report or a proposal are kind of the easiest because someone has said, here's a concept, here's what we think we should do. What do you think? So that's kind of least time consuming and easiest to do. Workshops, if you're participating in a workshop, are a little more complicated because you have to prep, and you're sort of, at that point, it'll be actually someone saying, here's our proposal for what to do. Testimony is a lot more involved because you have to have a witness, and the witness has to write their testimony and their rebuttal testimony, and then you have to prep them for a hearing, and that's a lot of work. And honestly, while C4AT almost always participates in evidentiary hearings, we usually don't have anyone providing a testimony, any testimony, because honestly, often you need like an economist or some other very expensive expert, and we just don't have that. We don't have the money for it, quite honestly. But we're still allowed to ask questions of other witnesses and introduce documents. So so I would say yes, comments on staff report, easiest way to do it. Also, I just want to reiterate, if you do comments on like an order instituting investigation, the initiating document, that's all you got to do. You're done. It's just a question of how important things is. And some of your decision sort of shifts as, the commission might issue an interim ruling or, decide a couple of issues, but not all of them. Then you may need to reevaluate, hey, what do we want to do here? But yeah, I'd say, yeah, it would be staff report or proposal, workshops, and then testimony. I cannot speak to how much work it is to organize folks to show up at a PPH, because I could not organize a closet. Like organizers are amazing. And you have to call everyone 40 times to do it. So I don't know how much work that actually is. So I'll defer to you, Patrick, I guess, on how much work that is. But yes, I'll just stay in my lane. And then I already talked about hearings here where you just have testimony, you cross-examine. I'll say one thing about evidentiary hearings is the fact is you're usually talking to experts who have testified a bunch of times before, so there's never going to be a gotcha moment. And the rule for evidentiary hearings is you never ask a witness a question you don't already know the answer to. But they're a lot of fun. So we talked about what the record is. I just want to reiterate that while the commission can only rely on information in the record, the non-record evidence does influence them. So if they hear these stories, that may say, well, I think this is the right solution, and then they'll rely on information in the record to support that. Let's talk about the proposed decision. So then you can wait anywhere from a couple months to 2 years for a proposed decision to come out. And basically, twice a month, sometimes once a month, there are commission voting meetings, and a proposed decision has to be circulated at least 30 days before the voting meeting if the commission's going to be able to vote on it at that voting. So there will be a proposed decision that comes out, and then you have a chance to comment on the proposed decision and then provide reply comments as well. Comments on proposed decisions are really supposed to identify, oh, hey, you got some facts or some law wrong there. So they're not the ideal vehicle to, excuse me, to get your thoughts in. But if you just found out about that the issue is live, it's worth doing. And then based on those comments, the commission can make changes to the draft decision. Oh. Frog in my throat there. If they're minor, sort of non-substantive edits, they can go ahead and vote on it. But if there's big changes, you have to invite another round of comments. And then at the voting meeting, there will be an agenda. Typically non-controversial stuff or stuff the commission doesn't want to spend a lot of time talking about goes on what's called the consent agenda. And they start the meeting by saying, let's vote on the consent agenda, and they approve everything in the consent agenda. If they want to have more discussion about it, if it's a more politically sensitive, or maybe there's a little bit of disagreement, they put it on the regular agenda. And then there's some discussion at the public meeting, and then they vote on it. And then there's a confidential agenda, but that is really for stuff like if it's an employment issue they're dealing with, or if they're involved in litigation somewhere. So you won't really see a proceeding show up on the confidential agenda. And then finally, you can be all ready for the vote, all ready for things to happen. And the commissioner or commission staff can just decide the night before to put the item on hold. So there's no actual vote. And then you have to wait for the next voting meeting to happen. It's a little frustrating. So then I apologize. I use this picture all the time because it cracks me up. Something fierce. Basically, if commissions 5 commissioners, as long as at least 3 commissioners vote aye, then the decision becomes final. And if the commission votes no, then there sort of depends on next steps. Like we could go back to the drawing board. Sometimes the commission will just sort of shrug and give up. Honestly, in recent years, I have not seen a lot of decisions. And I have one more bonus activity here, which are called ex parte communications. Just ex parte communications refers to a communication about a proceeding that is made when not all the parties to the proceeding are present. And this is its own topic because depending on what kind of proceeding you're involved in, you may be able to just go talk to commissioners and their staff and not have to report it to anybody. Or you may have to, you may be allowed to talk to commissioners and their staff, but there's a bunch of reporting requirements about it, or you're not allowed to talk at all about it. But the reason I love ex parte communications, especially for sort of communities that have really important issues, is that it gets you actual face time with the folks making the decision. And that's really powerful and really important. And how I say, you can deny a lot of stuff. Providers can say, oh, well, we know that we have to provide good service quality to everyone in our service territory, but we had this economist do a study and he says that everyone's getting good service quality. Hooray. But if you have someone stand up and say, every time it rains, my service goes out, you can't deny that lived experience. It's a lot harder to push back. Yeah, if anyone is interested in meeting with a commissioner's office or commissioner's offices, I am happy to talk through how you do that. It's for me, my approach has always been, when I used to deal with actual companies more in my old job, is like, we either meet with the CEO or we meet with nobody. This is an extension of that, saying we're going to talk to leadership. We're not going to get it pushed off to someone who will take notes and then promise to do. Ooh, got 60 seconds. Also, I am happy to hang around afterwards to answer questions. I should say that, so don't panic. My last little section is how to stay out of trouble. I think people often get a little intimidated by, like, oh no, I might break a rule and then, I don't know, get dragged off to prison or fined or whatever. It's actually pretty hard to do. This is rule 1.1, which is really the behave yourself rule in the commission rules. Don't need to read all that because I've broken it down on my next slide here, which is basically, you have to be respectful to the commission, members of the commission, and administrative law judges. Note, it does not say other parties there. You should be respectful to other parties. Like, don't be a jerk. There's no need to. And actually, the commission really does not like sort of bulldog advocates who are always fighting. And the other one is never mislead the commission or its staff by an artifice or false statement of fact or law. So you can't lie to the commission. The important part of this is you also can't lie by omission. So if you say, oh, I have a bunch of evidence that in my area service quality is terrible, but there are some areas where service is good, sort of required to also say, oh, there are some areas where service are good, but not all of them. And so they're terrible. That's really all you have to do, is don't lie and be nice. So, and you really have to do something wrong repeatedly for the commission to decide to chastise you for it. So, yeah, we're just about finished there. So, yes, I have just shown to you the most secret machine in my entire factory. That is all I do, is shout a lot about the way things should do. And I just want to reiterate here, like, community needs, perspectives, and most importantly, solutions. Those are going to be what make things work. We need to make those known. This process looks intimidating, and it's very sort of frustrating and panic-inducing when you're driving towards a deadline, but it is very forgiving and very flexible. And your voice is stronger than any argument industry can make, because the only arguments industry can make is sort of say, well, generally, things are all right. But, but no, you'd say, no, there's here's some actual facts. Here's what it's like in the real world. Why didn't you come down and visit us there, industry? So yeah, I'm really hoping that you walk away from this not only being excited about participating at the commission, but also feeling like you could explain to someone else why they should participate at the commission. And I want to thank you for all of your time. With that, if you have any questions, now you can ask them now. Later, just shoot me an email and we can talk.
I have a quick question, Paul. When you're the easy route to becoming a party is to file comments on the initial document. Can those comments be fairly cursory, or do you have to have some deep fact and analysis?
So it could be something like, so we like, I'll just say, this is who our organization is, and here's who we represent, and we've heard from this community X, Y, and Z, and the commission ought to look into that. Because those opening comments on the initiating document, that's not, you don't have to present sort of your case in chief there. You just have to say, hey, here's what the commission could consider during this proceeding. So really, really short and sweet. You could also do like a 40-page brief if you wanted to, but you could probably leave that to me. So.
Okay. And would that be, and that's where you would need to follow those 13 technical requirements in terms of form and form?
Yeah, and so, but as I said, the best thing to do is probably just reach out to me and say, yeah, because I can send you a document that's already formatted properly, and you don't have to.
Oh, great. Very helpful. Thank you.
Yeah.
Thank you so much, Paul. Any other questions? I'm looking at the chat here, but if you have a specific question for Paul, please feel free to come off chat and ask your question. That was a lot of information to take at once. So thank you so much, Paul, for walking us through that.
Yes, one of the things that's, I think, daunting to folks at first is there's kind of that's a whole lot, right? But once you identify a proceeding that's a specific proceeding you're like that you're interested in, it gets a lot simpler, because right now it's all kind of very abstract. Yeah, and speaking of proceedings you might be interested in it, we're supposed to get a proposed decision in the service quality proceeding, which is going to create service quality rules for wireless and digital voice services any day now. So there's a great opportunity to write some comments there. So if you're interested in doing that, I am happy to help out. I should also mention, I am happy to help out, and I am able to help out in thanks to the generosity of Cal Forward. So thank you for that. But also just between you and me, it's probably something I'd do for free on my own, but there we have it.
You heard it here first, folks. Paul is willing to help. Thank you, Paul, for that offer. Not seeing any questions. Feel free to follow up with myself. Paul, Paul's information is on screen, so he's probably the best person to go to. Just want to draw attention to a couple things in the chat. Patrick gave an example of an initiating doc with some snazzy formatting you can use. I posted a link to last Friday's webinar presented by Cynthia and Carolina from Oakland Undivided. That is now up. If you were not able to listen to that, that's a great resource for you too. And just as a closing reminder, we will be sending out a post-event survey. We want to hear from you on this event, how we can make future events at California Forward better, and would love to hear your feedback. If you want to stay on, Paul's offered to stay on a few more minutes to answer any questions you might have. But with that, we're about 6 minutes after the hour. We know you all are eager probably for lunch, as I am. So we will close there and say thank you to you all for joining today. Special thanks to Paul Goodman, the Center for Accessible Technology, for partnering today and sharing all the details and the Willy Wonka machine. We appreciate it. Thanks all. Have a good one.
Really appreciate it. Thanks for putting this together, California Forward. Thanks, Paul. National treasure.
Well, Well, thanks, Paul. Looks like we have a few folks still on. Feel free to stay on if you have a question. But if not, or you're a note taker, I may kick you off of the Zoom. So let's see who sticks around here. I'm gonna stop our recording.